Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, listen, we have been geeking out on a lot of different things, whether it's been triggers, traps, pistol braces, various other things, and it's really been keeping us distracted from some very important things going on at the appellate level. Now, a lot of my Washington viewers, we've been very closely watching Duncan v. Bonta because we out here in Washington also have a magazine ban similar to the one that's being challenged in California. However, many of you around the country currently live in states where there is an assault weapon or assault rifle ban. Now, I know some of you are immediately freaking out that I'm using that terminology, but that's the terminology that's used in the statute. For my Washington viewers, we know that between our governor and our attorney general, they have made not one, not two, not three, but 4 runs at an AR ban already in this state, and they most assuredly will be making another one. That's why there is a case out there that all of us need to very carefully watch. And so we're going to geek out on that case a little bit today so you can understand what the case is all about and how important it is to your rights nationwide. So today, let's spend a few minutes and talk about why every state with an assault rifle ban better watch this case. Okay, so the case we're talking about today is Bianchi v. Frosh. Now, Bianchi v. Frosh is a challenge to Maryland's assault weapons ban. Assault weapons, semi-automatic rifle, things on the AR, AK platform. I know that a lot of you get really triggered when I use incorrect terminology. I use the terminology that comes from the statute. I'm not saying that this is technically the correct way to refer to these particular instruments. However, this is a challenge to Maryland's assault weapon ban. It was one of the 4 horsemen of cases that was sitting there about to be accepted or denied by the United States Supreme Court when this past summer they issued their rulings in Bruen. Now, as we know, because we've done a bunch of videos on that, Bruen significantly alters the landscape moving forward as to how we should analyze restrictive gun control measures, and candidly does an excellent job of protecting the Second Amendment rights of Americans moving forward. That being said, there are many of these restrictions still out there, such as the magazine restriction in Duncan v. Bonta, which a lot of my Washington viewers are very anxiously watching, and of course this crazy assault weapon ban that came out of Maryland. And by the way, Maryland is not the only state to have similar bans. New York, New Jersey, California are 3 that come to mind. I'm pretty certain Hawaii is probably on that list as well. Now, this case had, of course, been any time that somebody had challenged Maryland's assault weapon ban, the appellate courts, the trial courts, and the appellate courts had always applied that 2-part test. Does the statute restrict activity, which is typically protected by the Second Amendment? And then, even after analyzing that, we look at the second part, which is, well, does the government have an interest here that outweighs the limited intrusion into that individual's rights? And Bruen essentially did away with that 2-part test. And what the plaintiffs are arguing here, the appellants in this case, is very wisely is, hey, listen, it's a new day. It's all new rules. All of the cases, and the case that particularly was relied upon in this was a case called Colby v. Hogan. That was the first challenge to Maryland's assault weapon ban. And of course, that challenge had been denied, saying that a couple of things. Number one, that the Second Amendment didn't necessarily protect all types of firearms, that it actually didn't protect assault weapons, and that even if it was protected, there was an outweighing governmental interest that justified the intrusion into the individual's rights. And it's that balancing test that allows all of these restrictions to upheld. Appellant's counsel here correctly points out in their pleadings the Supreme Court's decision in New York State Rifle and Pistol Association v. Bruen establishes that plaintiffs must succeed in this challenge to Maryland's outright ban on semi-automatic rifles owned by millions of Americans. Bruen unequivocally reaffirms that when a law is challenged on Second Amendment grounds, the court's analysis of the challenge restriction must be rooted in the text of the amendment and the history showing which types of firearms regulations were accepted at the founding as consistent with the right to keep and bear arms. Indeed, the court clarified in Bruen that the only way that a law burdening conduct falling within the Second Amendment scope can be upheld is if the government can demonstrate a historical tradition of regulation rooted in the founding era that has burdened the right in a similar way and for similar reasons. And they went on to further state then, with respect to the Second Amendment's text, the court reiterated that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. And that's a big argument that Maryland and a lot of these other extremely blue states make, is like, hey, listen, when they wrote the Second Amendment, they didn't have any idea that there would be these semi-automatic rifles with high-capacity magazines and all of that stuff. But I will remind everybody that when they wrote the First Amendment, they also didn't think we'd have Facebook, Twitter, Instagram, and YouTube, but I digress. Now, in pointing out that the relied upon law to justify this ban was no longer good, appellant's counsel correctly points out, first, this court's decision in Colby v. Hogan is no longer good law. In its principal holding, Colby expressly refused to apply the common use analysis that Bruen has now confirmed is dispositive for establishing constitutional protection for types of arms. And Colby's alternative holding relies on the intermediate scrutiny analysis that Bruen expressly overruled. So they're saying that, hey, listen, Colby's wrong on a couple of different grounds. Number one is Colby refused to take a look at the argument that, hey, the Second Amendment protects the types of common use firearms that are in use today, which is what was said in Heller, but was reaffirmed in Bruen. So yes, the AR, a firearm, with a semi-automatic rifle, which a firearm that the ATF themselves says is one of the most commonly used firearms for self-defense purposes, constitutes a firearm which is in common use at this time, and therefore the Second Amendment protects it on those grounds standing alone. But however, even if they had believed for some reason that that was not the case, their use of that second part of the analysis, the intermediate scrutiny, that balancing test, was also improper. So therefore, the case that the state of Maryland relies upon is not good law. Now, the state of Maryland's attorneys, of course, are not persuaded by this, and despite the fact that this is a political party that screams the rule of law, the rule of law, the rule of law, take a look at how the state of Maryland's attorneys responded to this pleading. 1. Is the court's en banc decision in Colby v. Hogan controlling precedent in this case because that decision held that assault weapons fall outside the scope of the Second Amendment right to keep and bear arms? 2. Even if not controlled by Colby, should this court follow the ordinary procedural course and remand this matter to the district court to allow the parties to develop a record upon which this case can be properly decided? And 3, is Maryland's assault weapons ban consistent with historical tradition of prohibiting extraordinarily dangerous weapons that pose heightened risks? And while all 3 of those arguments are disingenuous, take a look at number 2, because that is exactly what happened in Duncan v. Bonta, which is, hey, we got to punt this thing all the way down to the district court. They know that this law is going to get ruled unconstitutional, and rather than accepting defeat and upholding the Constitution, they want to play as many stall and delay tactics as humanly possible before Americans get to enjoy their God-given rights. And this is one of the points that Maryland is arguing, and you're going to see California arguing this, you're going to see New Jersey arguing this, is that what the Heller and Bruen decisions basically said is listen, the only real historical tradition we have of banning firearms are the dangerous and unusual weapons. And so Maryland is quick to point out, well, it's an AR, so of course it's dangerous and unusual, and that's how California has argued it as well. But the term is dangerous and unusual, of course, would mean that a firearm that is not relatively common in use. It would be an odd or exceptionally weird piece to be using. However, semi-automatic rifles, ARs, assault weapons, whatever label you want to give them, are in fact one of the most popular firearms used for self-defense and recreational purposes and for hunting purposes anywhere in the United States. Millions and millions are lawfully owned every day by Americans, probably second only to the modern handgun. Okay, to give you a quick historical perspective on what the plaintiffs did here to get to this point, When they filed suit in the District Court of Maryland, of course, Colby v. Hogan was already the controlling precedent in that state. So their suit was almost immediately thrown out. Now, they very correctly argued that it had been incorrectly decided and that the court should overturn that decision. They then appealed to the Federal Circuit Court, which again said, hey, wait a second, isn't Colby v. Hogan controlling precedent here? And Bianchi claimed, well, yes, it is. However, it was incorrectly decided and this court should overturn it. Of course, they got a big thumbs down. So then they applied for certiorari to the United States Supreme Court. And that's when this case was now kicked back down to Maryland to figure this out using the correct rule of law. Now, is Bianchi on incredibly stronger grounds now with the enunciations by the Supreme Court in Bruen? It most certainly is, and I think they summed it up best when they argued. Although this panel, like the district court before it, was bound by Colby when it issued its per curiam decision, the Supreme Court's decision in Bruen rejected the reasoning underlying both of Colby's holdings and explicitly abrogated the decision. Colby is thus no longer good law, and this court must now assess Maryland's ban on popular semi-automatic rifles anew under the appropriate standard. Bruen also unequivocally holds that the appropriate standard must hew to text, history, and tradition of the Second Amendment, and in the context of a flat ban on firearms, the government cannot ban firearms that are in, quote, common use. Since the banned semi-automatic firearms are in common use, plaintiff's right to possess them is protected by the Second Amendment, and judgment must be entered in plaintiff's favor. And that, in a nutshell, is the most clear and concise statement of the law. Can an assault weapons, an AR ban, a semi-automatic rifle ban, can it stand? Knowing that these types of firearms are some of the most common firearms in use, some of the most common firearms in circulation, and some of the most useful firearms for a multitude of purposes, a flat-out ban on these types of firearms is constitutionally impermissible. And that's the point that we need to keep pounding home here, which is, even though the amendment was ratified in 1791, the types of firearms that are in common use today are those that are protected by the Second Amendment. Plaintiff's counsel very correctly and wisely points out, in distilling this test, the Bruen court spent significant time describing how lower courts, like this one, are to proceed in Second Amendment cases. As particularly relevant here, Bruen described the proper analysis of the term arms. That word, Bruen affirmed, has a historically fixed meaning, but one that, quote, applies to new circumstances. It thus covers modern instruments that facilitate armed self-defense. Accordingly, the text of the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. The court then explained that much like we use history to determine which modern arms are protected by the Second Amendment, so too does history guide our consideration of modern regulations that were unimaginable at the founding. So that's really important. When we're going back and we're taking a look for a historical analog as to another type of restriction similar to this, which would then support the constitutionality of a more modern restriction, we don't go back 10, 20 years. We don't go back 30, 40 years. We go back to the types of restrictions that were ratified at the time that the Second Amendment was ratified. We take a look at the types of restrictions that were in common use in the late 1700s and early 1800s. The mere fact that there has been more modern restrictions in the 1990s and early 2000s means that, in fact, there is no historical analog to it. And plaintiff's counsel here was very quick to point out this analogical reasoning requires only that the government identify a well-established and representative historical analog, not a historical twin, to the challenged regulation. But to be a genuine analog, the historical tradition of regulation identified by the government must be relatively similar to the restriction before the court today. And then, of course, plaintiff's counsel says, hey, number one, the Colby opinion is faulty because you never even did a historical analysis, okay? But even had you done a historical analysis, you wouldn't have found anything to support it, but that's what's required of you now. As they state, Bruen specifically rejected Colby in yet another way. Bruen counsels that lower courts are to assess the validity of a firearms regulation by comparing them with the nation's historical tradition of firearms regulations. Yet the Colby court affirmatively declined to undertake any historical analysis whatsoever. The majority opinion never uses the word history and only references historical once in a passing quotation of the Heller opinion. Such an ahistorical approach can no longer stand. Bruen has now made clear beyond dispute that this court must indeed answer the question of whether the arms banned by Maryland are in common use, and if they are, they cannot be banned. So the case again is Bianchi v. Frosh. And listen, if this court applies the rule of law, all they got to do is just apply the rule of law as announced by the United States Supreme Court. There is no way that Maryland's assault weapons ban will stand constitutional muster. Therefore, there is no way that California or any of these other states that currently have these types of these bans will be struck down. And for my viewers in Washington State, which we are concerned about, our Attorney General, who is now most assuredly this next legislative session will be making another run at an assault weapons ban, this could essentially preclude that from happening. The case again is Bianchi v. Frosh. We will put a link for everything down below so you can follow it. In the meantime, if you have any questions about this case or anything else related to your Second Amendment rights, remember, you can always contact us at WashingtonGunLaw.com, or, of course, you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.